In this video, I'm going to give you the exact way CEOs protect their wealth with 5 powerful strategies. I'm Santiago Cueto, board certified international business law expert and best-selling author. I've helped hundreds of CEOs protect their wealth with the exact strategies I'm sharing with you today. All right, imagine building an empire only to have a target painted on your back. For Florida's most successful CEOs, that's not just a bad dream, it's a daily reality. Every deal you sign, every move you make, it all makes the target bigger. What happens when a business deal goes sour, a disgruntled employee decides to sue, or a simple accident turns into a multi-million-dollar lawsuit? Suddenly, everything you've worked for, your home, your savings, your family's future, is on the chopping block. They're not just coming for the company, they're coming for you. But the smartest players in the game do things differently. They don't just play offense in the boardroom, they play serious defense with their personal wealth. They use a handful of powerful legal shields to make their fortune untouchable. The first and most powerful shield in any Florida CEO's playbook is surprisingly simple: their home. Here in Florida, our state constitution gives us one of the most generous homestead exemptions in the entire country. In simple terms, your primary home is protected from creditors, and it doesn't matter how much it's worth. Whether it's a quiet suburban house or a sprawling billion-dollar waterfront estate, if it's your permanent residence, creditors from business debts or personal injury suits can't force you to sell it. Now, this isn't just some minor tax break. It's a full-blown constitutional fortress. Other states might cap this protection at a few $100,000, but Florida has no cap at all. This lets CEOs invest millions into their homes, knowing that money is safe from most legal attacks. The protection covers your home on up to half an acre inside a city or 160 acres in rural areas. To get this shield, you have to prove it's your permanent home. While having the title in your personal name is the clearest way, Florida courts have extended this protection to homes held in certain types of trusts, as long as it's clearly your primary residence. Now, it's not a magic wand. This won't stop a mortgage foreclosure, and it won't protect you from the IRS. But for the kind of business lawsuits that keep CEOs up at night, the Florida homestead is an incredible first line of defense. We've seen executives lose everything, yet their multi-million-dollar homes stayed completely safe, all thanks to this unique Florida law. Now, the second secret weapon, especially for married CEOs, is a special type of joint ownership called Tenancy by the Entirety, or TBE. Many states limit this to just real estate, but Florida lets you use it for almost anything: bank accounts, investment portfolios, even cars and boats. So how does this legal framework work? When a married couple owns something as TBE, they don't own it 50-50. The law sees them as one single unit where both people own 100% of the assets together. And here's the knockout punch: a creditor with a claim against just one spouse can't touch property owned as a TBE. To get to that asset, they need a judgment against both spouses. Now, for a CEO, that's a game changer. Let's say a business lawsuit ends with a personal judgment against you. If your bank accounts and brokerage accounts are titled as tenancy by the entirety with your spouse, a creditor who can only sue you is out of luck. Your family's core assets are walled off from your professional risks, but you have to set it up right. While real estate and bank accounts have a strong presumption of being TBE for married couples, with other personal property like cars or boats, you need to be very specific with the titling. When you're opening a joint financial account, the paperwork must clearly state tenants by the entirety. If you skip this step, you could lose this incredibly powerful protection. Every business owner knows that forming an LLC is step one for protecting your personal assets. But Florida's elite take it a step further, using the unique power of a multi-member LLC. Here's the key difference. If you own a Florida LLC by yourself, a single member LLC, and someone gets a personal judgment against you, a court might let them take over your company to pay off your debt. Your entire business could be seized and liquidated. But with a multi member LLC, an LLC with two or more owners, Florida law offers something much stronger called charging order protection. This is a creditors only remedy. A charging order acts like a lien. It says that if the LLC decides to pay out profits to you, that money goes to the creditor instead. The key words there are if and when. The creditor can't force a distribution, they can't vote, and they definitely can't seize the company's assets. This gives you and your partners all the leverage. You can structure the LLC so that profit distributions require a unanimous vote, meaning you can simply decide not to pay out anything while the charging order is active. The creditor is stuck holding a piece of paper that might never get them paid, which usually forces them to the settlement table for pennies on the dollar. By making a spouse, a trusted partner, or a specific type of trust a co-owner, you turn a simple LLC into a fortress that protects your business from your personal problems. Now that's powerful. Now we're getting into the really advanced stuff now. If you're a business owner finding this valuable, do me a favor and hit that subscribe button. We put out videos like this to help you protect everything you've worked so hard for. Now this next move sounds like it's straight out of a spy movie, but it's a completely legal and brutally effective tactic called equity stripping. The whole point is to make valuable assets like rental property, a vacation home, or a yacht look worthless to a creditor. Think about it. An asset with a ton of equity is a juicy target in a lawsuit. If you own a $2 million rental property free and clear, a creditor will be drooling over it. Equity stripping works by placing a strategic lien or mortgage against that asset, which strips away the visible equity. So how is it done? A CEO might set up a separate friendly LLC and then have that LLC give them a loan. That loan is then secured by a big mortgage on the rental property. The loan money doesn't just vanish, it gets moved somewhere safe, like into your protected Florida homestead or another protected account. Now, when a creditor sees that $2 million property, they don't see $2 million in equity anymore. They see a property with a huge mortgage that gets paid off first. The hassle and expense of fighting that friendly lien makes the property a terrible target. This tactic gives you incredible leverage, pushing plaintiffs to settle for a fraction of what they want. The key is that it has to be done before a lawsuit is even on the horizon, or it can be challenged as a fraudulent transfer. When you do it right, it's like making your assets invisible to your enemies. Now, for the highest level of security, the absolute gold standard, the savviest CEOs use the ultimate legal fortress, an offshore asset protection trust, usually in a place like the Cook Islands. This is the financial version of moving your most valuable assets into a vault in a foreign country that plays by its own rules. And here's why it's so powerful. When you move assets, cash, stocks, ownership of your LLC into a properly structured Cook Islands trust, you take them out of the reach of U.S. courts. A licensed foreign trustee is now in control. Now, if a court hits you with a judgment, that ruling has almost no power in the Cook Islands. The creditor can't just take their U.S. judgment and have it enforced there. They have to start a brand new lawsuit from scratch in a foreign court, which is incredibly expensive and difficult. Plus, the Cook Islands has a very short 1 to 2 year window for someone to claim a transfer was fraudulent. If you set up the trust before that window, a creditor's claim is likely dead on arrival. Now, these trusts also include duress clauses. If a U.S. judge orders you to bring the money back, the foreign trustee is instructed by the trust to refuse your request because you're acting under legal pressure or duress. This makes it impossible for you to obey the court order, protecting both you and the assets. While it's a complex strategy that demands perfect execution and U.S. tax compliance, it is the ultimate firewall for your wealth. So, from the Florida Homestead Exemption to the global fortress of a Cook Islands trust, you've now seen 5 of the most powerful strategies top CEOs used to shield their wealth. Each one adds another layer, making assets harder to find, harder to reach, and less attractive to attack. But here's the main takeaway: asset protection isn't something you think about after you get sued. By then, it's usually too late. Real financial security comes from building those legal walls long before a storm ever appears on the horizon. It's about using the law to smartly separate your professional risk from your personal life so that one bad day at the office doesn't destroy everything that you've built. Protecting your wealth requires a custom built plan. If you're a high net worth individual or CEO in Florida and you're worried about your exposure, now is the time to act. I'm Santiago Cueto, your Florida business attorney. Be sure to subscribe to my channel and watch more of my videos right here.